Last week we have talked about separate legal entity, okay, and we have discussed about Solomon and Solomon. Okay, we know that Section 21 of the Companies Act 2016 talks about separate legal entity, and then that based on the Companies Act 2016, but the origin, okay, the origin of this section came from an English case of Solomon against Solomon and Company Limited in 1897. This is such a landmark case because before this, um, the court or the law is always recognized that the owner and the company are the same person. But after this case, okay, after this case, the court had held that the company and the owner of the company are two separate persons. Okay, so this is why this case is such a landmark case. And we also learned that if we follow the law strictly, meaning if we follow the principle of separate legal entities strictly, it may give rise to injustice. Okay, why? Because the objective of the law is to dispense justice. But if we follow the law strictly, okay, if we follow the law strictly, it may cause injustice. Okay, because this principle of separate legal entity can be manipulated, can be used in certain circumstances to negate or to get away from justice, to cause harm to the society. So that's why in certain circumstances, the court had held that they will look behind the corporate bill. Okay, so last week we have talked about the first case or the first circumstance whereby the court may uplift the corporate bill. The first circumstance is in the case of enemy aliens, right? We have discussed this Daimler against Continental Tire and Rubber Company. It is during the World War II. So the court in this case had held that a company, okay, in a company which is controlled by enemy alien, all right. In that circumstance, the court may uplift the corporate bill and see who are the directors, okay, who are the directors behind that company. Okay, so that is the first case that we have discussed last week. I think we stopped here. Okay, we stopped here last week at the case of enemy alien. So this week we're going to proceed further. Okay, proceed further on the second circumstance or second situation when the court will uplift the corporate will. Okay, in case of an attempt to avoid legal obligation. Okay, in the case of Guildford Motors Company Limited against Horn. Right. The fact of this case is an employee had a covenant in his contract of employment, which stated that he would not solicit his former employer customers. After he left their employment, he formed a company to solicit, meaning while he's working with this company, he in his contract of employment said that if he left this company, he will not solicit any of his former employer's customer. So he left. Okay, he left after a while. He left his employment with this company and formed his own company. And then this company soliciting customers from his former employer. So now, when his former employer knows about this, then they say that, hey, look, it is in your employment contract. Say that you cannot solicit from us, okay, your the customers of your former employer. But the argument by this employee says that I'm not the one who solicit the clients. It is the company. Since the company and I are two separate persons, so I do not breach my contract with you. So the court in this case say that the company could be restrained from competition as the previous employee had set up the company to evade his own legal obligation. So you see that sometimes your contract, this employee contract with the previous employer, right? So as we know that for the principle of sanctity of contract, the contract is only binding on the parties, okay, the parties to the contract. In this case, this former employee, okay, this former employee is using this principle, meaning the contract is between the former employer and him. So he formed another company which is not bound by this contract. And since this company and the former employee is two separate entities, so he said that he did not breach any legal contract. But in this case, the court says that if you form a company as a tool to commit fraud or to avoid legal obligations, then the court might, in this situation, uplift the corporate will and see who's behind the company. Meaning, when they uplift the corporate will, he will see actually the former employee is behind the company. So the court says that you cannot use, okay, you cannot use this separate legal entity when you wanted to commit fraud, or you wanted to you're using that company as a tool to commit fraud or avoid legal obligations, right? So that in the case of Guildford Motors Company Limited and Horn. Right. Next situation is in the case of group enterprises. Okay, group enterprises. As we know that, you have a parent company and then you have a subsidiary, right? The parent company and the subsidiary are two separate entities. They're two separate companies. They have two separate company numbers. So they are two separate person, okay, two separate personal entity. But then in this DHN Towers against Tower Hamlets, okay, the fact is DHN carried on business from premises owned by the subsidiary. Okay, meaning DHN is the principal or the parent company, and he operated from the premise owned by its subsidiary. The subsidiary itself had no business activities, but both companies share the same directors. The local authority acquired the premises compulsory but refused to pay compensation for disturbance of the business since the subsidiary which owned the premise did not carry on the business. Meaning, the action is against the subsidiary. Okay, the action against the subsidiary. So the court here held that the companies were, in economic terms, virtually interdependent, right, on each other and should be regarded as a single economic entity. Thus, there was a valid claim for disturbance since ownership of the premises and businesses activity were in the hands of single group. So in this case, the action is against, the subsidiary, right? And the parent said that, hey, look, as a parent company, we are separate legal entity from our subsidiary. Okay, so the action is against the subsidiary, but the court here readily say that, hey, look, although you are a parent company and then you have a subsidiary, but you are operating in the premise of the subsidiary, and the subsidiary itself do not have any business activity. So the court here ready to uplift the corporate bill and say that both the parent and the subsidiary are the same entity, right? Do you guys have any question before I move to the next situation? Any questions?
No.
No, doctor.
All right, cool. All right.
No.
Because I'm talking, okay, like a train, like a bullet train, then I don't know whether you guys are with me or not. Okay, right. Now, now we go to the indoor management rule. Okay, indoor management rule. Now, based on Indo management rule is based on the case of Royal British Bank against the Kwan, or what we famously call a Kwan rule. Where's my my slides? Hold on, yeah. My slides suddenly disappear. Okay. Now, why the law having this Kwan rule? Okay. Basically, this principle, this Kwan rule, says that any third party who deal with the company are protected. Okay. Even though the officer of the company do not have any authority to act on behalf of the company. Meaning, for example, in a company you have a directors. Okay, you have a directors. Then most of the time, all these directors have their own what they call this discretionary powers, meaning they have a limit to their powers. But then these powers are not known to the third party. Okay, for example, like I wanted to enter into contract with Tenaga Nasional Berhad, for example. Okay, Tenaga Nasional Berhad. I do not know Tenaga Nasional Berhad or the TNB internal policies. I do not know what is the limit of authority for the directors for the TNB. So when I enter into agreement with the TNB and I signed the agreement, and the TNB um, represented by one of these directors. I knew that that person is the director for TNB. So I assume that that director, he or she, may have the power to act on behalf of the company. But in every company, they have their own policy, they have their own procedures that certain directors can only acted based on certain limits of powers. For example, like they can only sign contract for 1 million and below. Okay, to 1 million and above, maybe a different director. Okay, a higher ranking director can sign. So I wouldn't know this. Okay, I wouldn't know this. So when I enter into agreement, signed by me and signed on the my counterpart assigned by one of the director of the company, um, even if that director do not have any power to sign on behalf of the company, according to this case, the Kwan rule, the protection will be given to me. Okay, because I am an innocent party. I do not know what are the limits for the person who signed on behalf of the company. So this is what we call by the Kwan rule. Okay, so why the law have this kind of protection? Because it try to protect the third party, okay, who entered into agreement with the company. So the company cannot avoid legal obligation, cannot avoid contractual obligation just because of the technicalities known only to them. Okay, they cannot turn around and say that, hey, look, this contract is not enforceable. Why? Because I do not have the power to sign on behalf of the company. You cannot say the director cannot say that. Okay, director, the moment he signed on behalf of the company, then that contract is enforceable against the company. All right, so this is what we call the Kwan rule. All right, so we finished the first part of the lecture. We finished the actually for the last week lecture. So we finish off today. Any question for the first part or whatever we have learned last week and the remnants of this week? Do you have any question before I move on to the duties of directors?
Sir,
Yes.
okay. I heard somewhere,
Hmm.
a company like offer one of their clerk
Hmm.
to sign a agreement to be a director,
Hmm.
but then all the salary is still based on the clerk position.
Hmm.
That means that the clerk, if he agrees on um signing of the agreement, he will take all the responsibility, right?
Hmm.
Okay, because I heard like it's like a fraud or something, because how can a clerk become a director in a company?
Hmm.
So I just want a clear answer on this.
Okay. Actually, it's a good question. Okay, it has something to do with our next slide. Okay, next slide on duties of directors. Okay, because the meaning of directors. Okay, your question is actually have a connection. Okay, connection with the meaning of directors. Okay, so okay, I'm going to answer your question. Okay, it's a good question. It's related to my next slide. Okay, next slide is about duties of directors. Okay, Putri.
Okay,
Putri.
okay,
All right.
okay,
I'm going to answer your question after this because
okay,
the
okay. No
answer
problem.
it is in the next slide of duties of directors. All right. Now, appointment of directors. Okay. Now we talk about directors. Okay. Section 196(1) says that a private company shall have a minimum of one director, and public company shall have minimum of two directors. Okay. This is a deviation from the previous Companies Act 1965, whereby the previous Companies Act says that all companies must have at least two directors. But with the amendment for 2016, it says that private company, which is a private limited, Sdn Berhad company, minimum number of director is one, and for public, you shall have minimum of two. You can have, but you can have more. Okay, you can have more, but this is alright. Okay, can I move on? Alright. And move on ya. Ahmad Yusof, can you mute your speaker? Ahmad Yusof. Ahmad Yusof, can you mute your speaker? Alright. Alright. Okay. Section 196, subsection 4 says the directors, okay, must be ordinarily resides in Malaysia and have principal place of okay. Meaning to say, section 196, subsection 4 says that you don't have to be a Malaysian citizen. Okay, you only need to prove that you reside in Malaysia and have a principal place of residence in Malaysia. So that's why you can see there's a lot of expatriates becoming directors in Malaysia. Why? Because citizenship is not a requirement to become a director in Malaysia. Okay, to qualify you to become a director, you only need to show that you have a residence in Malaysia, right? And a principal place of residence in Malaysia as well. Section 201 says that you must consent to be a director. Meaning before you become a director, you must sign a consent form to show that you consented to become director. Why? Because being a director, it gives you certain powers, it gives you certain discretion, and you must be accountable with these powers. Okay, just like Spider-Man, powers come with responsibility. So the moment you become a director, that appointment come together with um, responsibility. It comes together with duties under the law and the common law. So you must be aware. Okay, you must be aware that you are a director. So Section 201 says that you must consent. Okay, from being before you can be appointed as a director. And Section 202, 1 and 2 say that the appointment can be during the incorporation of the company or after the incorporation of the company by way of ordinary resolution. Right. So this is a bit technical, right? A bit technical. All right. This is kind of straightforward. Let's move on. Okay, now before you can become a director, okay, Section 198 says that you cannot become a director if you are undischarged bankrupt. Because if you are bankrupt, you cannot become a director. But if you are a director, then after that you become a bankrupt, then you will be disqualified. Meaning, a bankrupt cannot become a director. Why do you think that a bankrupt cannot become a director or not fit to become a director? Why? Why do you think?
I think because they will affect the company itself.
How does it affect the company itself?
Uh, let me think first.
In terms of financially?
How's that?
Maybe when the company want to apply for loan, and then the bank check the board of director is blacklisted or bankrupt, then it's difficult to loan approval.
Yeah. Okay. Basically, if you are a bankrupt, why do you become a bankrupt? When you become bankrupt because you cannot manage your own. Yeah, you cannot pay up your own debt, right? So
Yes.
you can't manage your own financial affairs. So if you can't even manage your own financial affairs, how people can expect you to manage the financial affairs of the company? That's one. Secondly, um, when you are bankrupt, then you hold a, let's say you manage a company while you are bankrupt. So you may be tempted, okay, to use the company resources to pay for your own interest, meaning pay out your debt, meaning you use your position in the company to your advantage to maybe pays for your debt, you know that. Okay, that's second reason. The third reason is based on contract. Why? Because um, when we learn about law of contract, okay, law of contract says that about capacity to contract. Okay, a person who has the capacity to contract is someone who has not been uh, disqualified by the law. Okay, the meaning of disqualified by the law is if you are not a bankrupt. Okay, so if you're not bankrupt, you can enter into agreement. So if you're bankrupt, then you do not have the qualification, do not have the capacity to enter into an agreement. So if you do not have the capacity to enter the agreement, how can you give consent? Okay, how can you give consent to become a director? Meaning, how can you enter into a contract with the company to become a director? So that's the three main reason why a bankrupt cannot become a director. Okay.
Doctor, sir,
Yes.
I have a question. Is it same with the board of trustee?
Why? Or what about board of trustee?
Yeah, is it same act that we can use?
Okay, if you are bankrupt, you cannot become a trustee. I think is the same reason. I think because if you cannot manage your own financial affairs, how can we trust you with the financial affairs of the beneficiary? All right. So it's very
Sir,
Yeah.
So how about the position of the head of department or head of any head of department actually or a
Okay.
division?
All right. It depends on the policy of the company. Okay, for example, like uh, in UniKL, it is allowed for you to be a director while maintaining employment with UniKL, for example. But in certain banks, or most of the banks, okay, most of the banks, if you are a director of a company, you cannot work with that bank. Okay, so this policy, that's internal policy. And then there is also, if not mistaken, when I was with the bank, you cannot be a bankrupt. Okay, why? Because again, the same reason, they afraid or the concern is, if you are a bankrupt, then you work with the bank. You holding the trust of the public. The public trust you with their money, so you may use that, or you may abuse the trust to pay off your own debt. Okay, so um, again, depends on the policy of the company. But then,
Sir, just one question.
yeah,
Is the company have the rights to investigate on the employee background?
okay. Usually they ask you to sign a SD, statutory declaration, saying that you are not a discharged bankrupt. You do not have any you're not holding any directorship position in any companies and all that. So when you sign the SD, meaning you bound by that statutory declaration, right? So if you breach that declaration, then they have the power to terminate your employment. On the investigation, okay, um, yes, sometimes they just look at the records of the SSM, for example. Let's say the company says that you cannot hold any director position with any that in any company. So they can check with the SSM. Okay, they can check with SSM with the record of SSM, and they see that yes, you are holding a director position in other company. Then they can terminate your employment. To answer your question, whether they
Why
can invest,
it
yes.
if let's say the situation when he or she entered the company is not declared bankruptcy, but they during the time, like say the MCO started, he or she is a head of department and have difficulties to pay the bills, the loans, everything. So it declared it bankruptcy. So the employee can terminate him or her. Is it possible?
Yes, if the policy of the company says that you if you are undischarged bankrupt, then you cannot maintain employment with that company. Yes, the company can terminate that based on the contract, because that is based on contract. So if you breach the contract, then the remedy for the innocent party, or uh, innocent party, meaning they can actually say that, hey, look, you have breached the contract. So now, based on the contract, if you breach the contract, then I have the power to terminate your employment. But usually the company will give you some time, or will give the person some time to actually remedy the situation. Go on and pay off your debt, and then come clean. If you cannot do it within certain period, then we need to terminate you from the employment. A bit harsh, but the rationale behind that terms, or that they do not want any person who in that position to have the power to abuse the position for their own advantage. Okay, because those who are bankrupt, they may have the tendency to abuse their power, okay, for their own benefit. But it doesn't mean that as a bankrupt you cannot work, right? You cannot work. So you need to work, or else how can you pay off your debt? So this is something which, okay, it's up to the company to decide. Okay, maybe um, demoted this person from head of department to become a normal employee without any powers, you know that. So that is something that it can be worked out. Okay, because being a head of department, he or she may have access to certain information, may have a certain powers to do something, all right, um, to his or her own advantage. So this is something which the rationale behind that terms and condition, right?
Okay, Doc.
Cool. Okay, now, if you're convicted in any offense relating to the promotion, formation, or management of a corporation, then you cannot become a director anymore. If you have been convicted of an offense involving bribery, fraud, or dishonesty, or you cannot become a director. Or you've been disqualified by the court again, okay? Then convicted of offense under section 213, 217, 218, 228, and 539. Basically, it's all, if you have been convicted of any of this, you cannot become a director. You become disqualified, okay, from being a director. Right. How do you resign? Okay, nothing wrong with you. Okay, nothing wrong with you, but suddenly this thing happened. Okay, section 208 one says that if you wanted to resign, you give notice to resign. Okay, so meaning this is a normal resignation. You no longer wanted to act as a director. Enough is enough. Okay, you wanted to enjoy your life, so you resign. But before you resign, you give notice. The same thing as a normal employment. Okay, if you wanted to end your employment, you just give your notice. Then off you go. Or you can retire. Okay, meaning after a certain age, okay, you are retiring from your directorship. Especially section in a public company, for example, after 70 years old, you must resign from your post. Okay, but if you wanted to become a director after your 70th birthday, uh, the uh, the general meeting, okay, annual general meeting need to appoint you on yearly basis. All right. But then for private company, there's no retirement age. Okay, only for public company. Third one, if you've been removed, okay, for example, like if the shareholders doesn't like or is not satisfied with your performance, then they can remove you. They remove you from your office in the annual general meeting. Number 4 is disqualified. Whatever we have discussed at the previous slide, you've been disqualified, then you have to vacate the office of your directorship. You become unsound mind. Okay, become unsound mind. Of course, you become crazy. Then medically certified that you are a crazy person. Then you are um, you automatic you have to vacate the position of that directorship. Okay, the next one dies. Okay, this one very straightforward. Okay, you die, of course you need to by default you vacate the position. Or you vacate your office, meaning you don't come and perform your duty. You go MIA, missing in action for 1 year. Then um, you are now vacating your office, so people can uh, remove you from your office, okay, from your position as a director. Now, answering Putri's question just now, okay, Putri asked the question that what if, Okay, what if a company enter into an agreement with a clock, right, to act and exercise powers of a director? So basically, that is the gist of Putri's question just now. Now, according to Section 2, okay, Section 2 says, director shall include the CEO, the CFO, the COO, or any other person responsible for the management of the company. All right, so now, according to Section 2, it says that any of that type, the person who bears that title, whether CEO, CFO, COO, or CIO, that, they will recognize as a director. Okay, and any other person who may not have that title but responsible for the management of the company, meaning maybe that title, the person's title is a clerk, a driver, for example, but he managed the company. Okay, he managed the company. So Section 2 says that even if you do not have the title of a director, but you are managing the company, then you will be regarded as a director. Okay, why? Because Section 213, subsection 1 says, anyone who is a director must exercise his power for a proper purpose and in good faith in the best interest of the company. Now, as I said just now, that with powers come responsibility, correct? So a director or directors, they have very wide powers. They have certain discretionary powers to manage the company, right? The buck stops with them. They're the one who calling the shot. So with that powers, the law provide some responsibilities to them. Meaning, yes, you have a very wide powers. You have very wide discretionary powers. You're the one who calling the shot, but it doesn't mean that your power is beyond, without any boundaries, without any borders. It's limitless. All right, you still need to exercise your power, okay, in certain limit. So what are these limits? Section 213, subsection 1 says that a director must exercise powers given to them under this act, which is the Companies Act 2016, for a proper purpose and in good faith, in the best interest of the company. Okay, so now, what is the limit? The limit is whatever your action is. Okay, whatever the action taken by the director must be for the proper purpose and in good faith in the best interest of the company. So this is the guideline. Okay, this is what the law says. If you wanted to exercise your power, it must be for the proper purpose of the company. It must be for the best interest of the company. It must be in good faith. Okay, in good faith. No more. There's no what they call this malicious, or when you do something, it gives you some benefit. Okay, it gives you some personal benefit. Cannot. Whatever you do, the benefit is only for the companies. Okay, not for your personal benefit. Okay, now the word is proper purpose, good faith, and best interest of the company may be a bit vague. You may ask me, Sharin, what is the meaning of proper purpose? What is the meaning of good faith? And what is the meaning of the best interest of the company? Okay, so it's all words, right? So now we look at how the court interpret all these words. In the case of Zaharin Haji Zakaria, okay, against Red Max and Berhad in 2016, volume 7, current law journal, at the page of 380. Now, the court says that, in other words, okay, this is the quotation from the case law. The court says that, in other words, a director of a company has to give his all to serve in the best interest of the company, of which he is a director. As a fiduciary, okay, the word fiduciary, the company is backed up by the statutory provision to expect nothing less from its director. Meaning to say, these directors are acting on behalf of the company. So when they're acting on the behalf of the company expect nothing less from its director to act on for the best interest of the company. So gone are the days when a director can be heard to say that he was a sleeping director and expect to escape liability. Meaning to say, if you're a director, you are a director. You cannot say that, hey, look, I just a director, but I don't really involved with the management. I do not know nothing. Okay. Whatever happened in the company, I do not know. So you cannot convict me for anything or for any action. You cannot say that. If you're a director, you are a director. So the court says that his duty, meaning the duty of the director, may appear onerous, but that is to be expected as he is part of alter ego of the company. Meaning, you are acting on behalf of the company. He is a fiduciary, a trustee. Okay, he is a fiduciary, a trustee. It is not his business to act like a rogue, much less to act to the detriment to the company. Meaning to say, first, you cannot say that you do not involved with the operation of the company, so you cannot be held accountable. You cannot be held liable. Secondly, the court says that as a director, you are a trustee of the company. So if you are a trustee of the company, so you are under the fiduciary duties. And because of all this, you cannot act arbitrarily, meaning you cannot act wantonly. You cannot act as per you wish. It must be within the boundary of the law. All right. You need to act on the best interest of the company, and you cannot work or you cannot do harm to that company. Okay, much less to act to the detriment of the company. Meaning, you must always strive to work to benefit the company. So you cannot do harm to the company. So this is in the case of Zaharin Haji Zakaria, okay, against Red Max and Abraham. Now, what's the meaning of best interest of the company? Okay, just now section 213 says best interest of the company, right? So what's the meaning of this best interest of the company? In the case of Petra Perdana Berhad, okay, against Tengku Datuk Ibrahim Petra Tengku Idra, Petra and others, year 2015, volume 8, current law journal at the page of 856. And this case was decided in the Court of Appeal. The CA means Court of Appeal. Now, in this case, the issue was whether the director had breached its duty to act on the best interest of the company under the old company law. The shareholders had passed certain resolution to set a limit on divestment of certain company asset, i.e. shares it held in other companies. The director had exceeded this limit when divesting the shares. Okay, now, just now as in Tekuan rule, okay, Tekuan rule, I said about the discretionary power of the company, right? Now, where does this discretionary power of this director come from? Okay, who limits the power? Okay, this limit or this power come from the shareholders. Okay, the shareholders will say that, okay, director, we appoint you as a director, but these are the limits of your power. Okay, you if you wanted to divest company asset or in other company, meaning shares, our shares in other companies, you need to get our approval first during the AGM or during the EGM. There's certain limit, meaning your power is to divest a certain what do you call this, certain amount of shares or certain amount in monetary terms, for example. But this director had breached the limit. Okay, had breached the limit. So now, the question is whether when the director breached his limit, is he acting not to the best interest of the company. So here the question is, what is the meaning of best interest of the company? Is it the decision, okay, opinion of the director, or the limit, okay, the limit set by the shareholders? So what does the court says? So the court says that best interest of the company means, okay, the Court of Appeal held that the shareholders' resolution provided a barometer as to what the shareholders gauge as being the best interest of the company. Hence, the shareholders' resolution. Okay, hold on, let me put in the charger. Right. Now, the court says that since the shareholders' resolution had gauged or had provided the barometer, so the court says that this barometer set by the shareholders in its shareholders resolution, that is the best interest of the company. So if the director acted beyond his power set by the resolution, then he failed to act in the best interest of the company. Okay, so in this case, the court says that what's the meaning of the best interest of the company? It means that whatever provided by the shareholders of the company in their resolutions. Why do you think that the shareholders resolution represent the best interest of the company? Why do you think? Well, what's your opinion? Do you agree with the court in this case? Anyone?
Sir, can you repeat the question, sir?
All right. In this case, the court says that what represent the best interest of the company is what being written or what being decided by the shareholders in their shareholders resolution. Okay. So meaning to say, okay, the court says that this is the resolution, the shareholder resolution represent the intention of the shareholders of the company, of what is the best for the company. All right.
Okay.
Okay, now, but the director may have a different opinion. So now, do you think that whatever decided by the shareholders written in the shareholder resolution, is that the best indication of the best interest of the company?
Not necessarily.
Why?
Not
Why,
necessarily.
Arif? Why, Arif?
I mean, wouldn't the barometer set by someone that has the highest shares in the company? Is that not the gauge?
All right. Okay. I can see the rationale behind this court decision, because the company, okay, the owners of the company are the shareholders, right?
Yes.
So the shareholders are actually co-owners of the company. So when they set up the company, they have
Sir?
certain intention. Yes, Muhammad Ridwan. You're saying something just now, Muhammad Ridwan? No, right? Okay, so when they set up the company, okay, they must have some certain intention why they set up the company. They must have some idea on how what is the what do you call this, the purpose of this company. So they must have some ideas on how this company should be run.
Yes.
So that's actually, I think, the rationale behind this decision. Meaning, when the court says that if you wanted to know what is the best interest of the company, we look at the shareholders resolution for some guidance on what represents the best interest of the company.
But sir,
Yes.
is it not like the shareholders appointed the directors to to achieve their best interest. So why they need to like doubted the directors?
Yeah, that's actually that's what been lingering in my mind, because as a director you need to make decision. Okay, you are bound by section 213 that you need to act on good faith. All right, on good faith for the best interest of the company. um but here is kind of catch-21 situation. Why? Because as a director, although you need to act on the best interest of the company, but at the same time you are bound by this resolution, right? So you are now acting beyond your powers. You're acting beyond your limit of powers. So basically you have breached your agreement with the shareholders. um, so I'm kind of okay. I kind of 50-50 on this. Okay, 50-50 on it, because yes, I agree that he breached the limit, but if he can prove, okay, if the director can prove that he do not personally benefit from this action, if he can prove that his action is for the best interest of the company, then why not? Okay, why not? But then, um, as it is, these are the decision by the court. Okay, so whether it's correct or incorrect is time will tell. Okay, because in future the court may have a different view on this. But as it is now, this is the situation. Now, for a proper purpose. Okay, the word for a proper purpose. What does it mean? Now, in the case of W and M Royce Limited, okay, a director by the name of Royce entered into a service contract with his company for a purpose of providing a pension for his wife in the event of his death, and without taking into consideration whether the contract was for the benefit of the company. Okay, so the whole object of this contract was held not to be binding on the company, for it was to benefit Mrs. Roy and not the company. Okay, this is a straightforward case. Okay, this director, Mr. Roy, when he is still alive, he entered into an agreement with his own company. The agreement says that if the director died, Mr. Roy died, then the company will give pension to his widow. All right, to his widow. Now, um, I have no problem with this decision, because as a director, when you enter into agreement with the company, it as if like you're wearing two hats. Okay, you are proposing, then the company accept. Who is the company? Is the director himself. So it's like he is proposing and he's accepting. Okay, at the same time. So he's when he entered into this contract doesn't give any benefit to the companies, because when the company give pension to his widow, what does the company get from this contract? Okay, apart from doing a charity to the widow, it doesn't give any financial advantage to the company, correct? So this is not this contract is for a proper purpose. Okay, because the proper purpose must benefit the company, not the widow of the director. Or any one of you disagree with this decision? I find it very straightforward.
Yeah, it's quite straightforward, yeah.
Yeah, right.
Yeah.
Okay, right. Okay, now we move on. Okay, section 213 also talks about reasonable care, skill, and diligence. Okay, And Section 214 talks about business judgment. Right. Section 213. Okay, Section 213. If you read Section 213, okay, it says, okay, hold on, yeah, let me find Section 213. It says that a director of a company shall at all times exercise his power in accordance with this act for a proper purpose and in good faith in the best interest of the company. Subsection 2 says that a director of a company shall exercise reasonable care, skill, and diligence with A. The knowledge, skill, and experience which may reasonably be expected of a director having the same responsibilities, and B. Any additional knowledge, skill, and experience which the director in fact has. All right, now, what's the meaning of reasonable care, skill, and diligence? Okay, in the case of City Equitable Fire Insurance Company Limited, 1925, Chancery means at a pilot level at page 407. Okay, the fact of this case like this. This company, this City Equitable Fire Insurance Company Limited, is an insurance company. All right. So as an insurance company, of course, you have this insured who paid premium to this company, correct? So it's a normal insurance company whereby you have all this insured paying premium to the company. So what happened was the chairman of this company, okay, the chairman of this company, he swindled all the premium for his own personal use. Okay, only one director, which is the chairman, do this. Okay, the other directors doesn't do this. The other director doesn't know about the chairman's scam or scheme, whatever in this case. But the chairman had been caught, okay, tried, then sentenced to jail. Okay, and what happened was, after the exposure of this scam, okay, all the insured came to the company, to this insurance company, and asked for refund. Okay, asked for refund of their premium. And this company had refunded all the premium to their insured, to their clients. All right. And of course, when they have returned all the money to the insured, all the premium money to the insured, and this company gone into bankruptcy. Okay, gone into bankruptcy. Now, the problem is this company have creditors. So now, creditors, okay, when the company become bankrupt, so the creditors try to get their money back. Okay, but then no more asset left with the company. So no more asset left with the company. They wanted to sue the chairman who did the scam, but the chairman had been sentenced to jail. Okay, no more asset. They cannot get any damages from the chairman. So what they do is they take legal action to the next best person, which is the directors. Okay, the directors of the company to recover their debt. So according to the creditors, which is the plaintiff in this case, the directors, okay, are not exercising reasonable care, skill, and diligence in discharging their duties as a director. Why? Because how can you not know your chairman is swindling money or embezzle money from your company? How can this chairman do all this without you knowing? Are you sleeping? No, are you guys sleeping? Okay, you don't go to the office. You don't you do not care what happened to the company and all that, and let this chairman do all this scheme, embezzling money from the company. So by doing this, or by not doing work well, the creditor said that you are not acting, you're not exercising reasonable care, you are not exercising reasonable skill and diligence in discharging your duty as a director. Okay, now then in the court, okay, in the court, during the hearing, and the court had made some decision. So the court come up with this ruling. Okay, one say that a director need not to exhibit in the performance of his duty a greater skill or greater degree of skill that may be reasonably expected from a person in of his knowledge and experience. Meaning, for example, as a director, okay, as a director, what are the skill that are expected from a director? All right. So if you imagine a director of the company, okay, what is the reasonable skill that you are expected from a director? So the word reasonable here is a bit vague. It's a bit ambiguous. Why? Because different company would require a different set of skill. For example, like if you're a small medium enterprise company, okay, selling textile, okay, in the area of Kampung Baru, Kuala Lumpur, a very small medium enterprise company. So you may have certain skill as a director, but the complexity of the business may not be very complex. Means you don't require a higher degree of skill to become a director for a small medium companies. But you compare that, let's say, if you become a director for Petronas, for example, multinational companies like Petronas, okay, where you have a very complex business structure. Then to become a director for Petronas, you need to have this higher degree of skill, right? So this is the meaning of degree of skill that may be reasonably be expected from a person of his knowledge and experience. Meaning, the meaning of degree of skill depends on the complexity of the companies. Okay, a small companies, you may not need a very high skill, but if you are a director for multinational company, then people will expect more from you, right? So this is according to the court, sorry, City Equitable Fire Insurance. Then the court also says that as a director, you are not bound to give continuous attention to the affairs of the company, meaning you don't have to be in the office 24/7. Okay, because a director may have other businesses outside. They need to play golf. They need to attend meetings. They need to what they call this. They need to attend meetings, conferences, all that. So,
sounds like fun.
pardon me.
Nothing.
Play golf, yeah, all right, okay. Meaning you cannot expect a director to be in the office 24/7. That's number two, all right? And then it is justified in trusting officials to perform such duties honestly. Meaning, as a director, you are justified to trust the company's officer. For example, like you wanted to know about the account of the company, so you call up your chief accountant of that company, give me the audited account or give me the account of this company. So when the chief accountant give you the set of accounts to you, financial report to you, then you it is justified for you to trust that person, okay, to trust that person, unless there is a glaring mistake of the account, which as a director it is expected for you to spot that mistake. But if on the surface it's all correct, it all looks nice, all looks good, then it is justified for you to trust the honesty of that officials, of that company officials. Okay, so this is what in the court held in the City Equitable Fire Insurance Company Limited. Right? So anyone wanted to ask the word reasonable care, skill, and diligence? I know a bit vague, right? So anyone want some clarifications, perhaps?
Sir,
Yes.
just a question. Is it you said the director is not um mandatory to attend the meeting and the office, right? And then is it the same? Is it the directors and the CEO duties are the same or kind of different?
Okay. So yes. Now, directors, when they can't come to meetings, okay, usually in the company they always say that if you cannot come for the meetings, you need to send your proxy or send alternate directors. Or even if you cannot come to the meeting, there are only certain numbers of meeting that you allowed not to come. But now with this new amendments, meetings can be done virtually. Means like this, like our Microsoft Teams. Right, so a director may be one in New York, one in London, one in Kuala Pilah, Negeri Sembilan, but they can still attend the meetings, right, virtually. So what I meant by you don't have to come to the meeting, what I meant by you are not bound to give continuous attention. It means that you need to give some attention to the affairs of the company, but doesn't mean that you need to give continuous attention. Means without any pause, without any breaks, without any what do you call this, without any break from that duty, meaning they don't expect you to be 24/7 for the companies. You may have to attend to certain things at that point of time, but after you finish that business, then you need to give attention to that company. So this is what I meant by you're not bound to give continuous attention. It doesn't mean that you don't come for meetings at all. Okay, that is callous. That is not reasonable. Okay, for what's the meaning of reasonable? You need to compare with your peers, right? When we talk about the law of thoughts, when we talk about the word reasonable care in the law of thoughts, how do we measure reasonable care? By comparing your action with your peers. So if a director duty is in question, okay, when you say that the director had breached his reasonable care, then you need to ask another director in other companies whether the director's action in question is reasonable. Okay, by not attending any meetings, for example, by not knowing how to read financial report, for example. So is it reasonable? So that is the gist of City Equitable Fire Insurance. Okay, so the word reasonable care here in section 213 is the same as when we talk about reasonable care in the law of thoughts. Remember how do we measure what's the meaning of reasonable care? Remember? In law of thoughts?
Yes.
Right, cool. Okay. Let's move on to another slide. Okay. Duties and responsibilities, section 218. Prohibition against improper use of property and position. Now, the word property here, it can be physical property, can be also mean by information as well. Okay, information, meaning you're using information to your own advantage. For example, for example, you are in the construction companies, all right? In construction companies, or development companies. Your company develop lands, for example. Okay, then you know that your company is developing a land, for example, a piece of land in Kampung Pandan, for example, Kampung Pandan, Kuala Lumpur, near that TRX. Okay, TRX in Jalan Tun Razak. Area adjacent to TRX is Kampung Pandan. All right. Now, you know that your company is going to develop or going to acquire land in Kampung Pandan for the purpose of developing that area. Okay, so you have you as a director, you have this what they call this information. You're privy to this information. So what you do is you tell your siblings, right? Hey, guys, you go and buy. Okay, you go and buy this land in that area, in Kampung Pandan area. Then we split the profit. Okay, 50-50 or 60-40, for example. Why? Because I got the information that my company is going to buy the land in Kampung Pandan and they're going to develop. So the price, okay, the price will shoot up. Okay, so we buy now. We buy the land now at a low price. Okay, and then when my company comes in to acquire the land, then we can sell at a higher price and make a profit. So that is improper use of property, meaning you are now using the information privy to you. Okay, property can be tangible, can be intangible. Tangible is the property of the company. Like, let's say you're using the company car to do your as a Grab driver, for example. So that is tangible. Intangible can be what we call this information. Okay, whereby you are privy to certain information, then you use that information to your advantage. Now, I think it's not about director, but in the US, for example, in the US, this committee, okay, in the US, in the Senate, they have this the committee for security, a lot of committees, and then they got what those Senate become committee members for certain committees. And it was alleged, or it was reported in the news, saying that these committee members, the senators who are members to certain committees, they have been briefed about the COVID-19 situation. All right, long before the COVID-19 become a pandemic. So they have been briefed by the intelligence committee or the intelligence agency that this COVID-19 will create havoc, will create a pandemic, and a lot of businesses will suffer. So based on this information, these senators, they also have shares in certain companies. So these senators, when they receive this kind of information, then they sell off. Okay, they sell off all the shares, or the bulk of the shares in certain companies. Why? Because they wanted to cut loss. Okay, because if they keep holding on to the shares, if people know about this information, then the price of the shares will goes down. So before people know about this, before the price of the shares goes down, they sell it off and make a profit. So this is one of the example on how can a person abuse information privy to them. Okay, privy to them, or only they know about this information because they are at the position to know about that information. Okay, they abuse their authority, they abuse their position for their own advantage, for their own benefit. Right? Okay, all right. Okay, it's straightforward, right? Now, fiduciary duties. Okay. Why fiduciary duties is important here? Because the director are acting on behalf of the company. So when you're acting on behalf of the company, so you are a trustee for the company. You are the trustee for the shareholders, and the moment you become a trustee, the moment there is a trust, then there's always be a fiduciary duties, right? So the directors owe fiduciary duties to the company. Okay, when I say company, I meant the shareholders of the company. The moment you are under the fiduciary duties, then you cannot make secret profit, which may be in conflict with the company's interests. Okay, so now in the case of Aberdeen Railway Company against Blakey Brothers, the year is 1843 to 1860. Okay, All England Report, page 249, 252, by House of Lords. Okay. The court says that the directors are a body to whom is delegated the duty of managing the general affairs of the company. A corporate body can only act as an agent, and it is, of course, the duty of those agents, meaning agent here they're referring to the directors, the duty of those agents so as to act as the best to promote the interests of the corporation whose affairs they are conducting. Such agents have duties to discharge of fiduciary duties to its principal. All right, now, what happened in Aberdeen Railways Company against Blakey Brothers? This company, Aberdeen Railways, they have directors, okay? And these companies are basically, Aberdeen Railways means they're dealing with railways, okay? They're dealing with railways. They have built railways for the train. So what happened was this group of directors, okay, they are directors for Aberdeen Railways, but they went outside of the company, maintained their position as a director, but they went outside. They formed another company. They form another company is still okay, but when they form a company, that company provide raw materials for railways. Okay, raw material like iron and other raw materials lah. Okay, raw material, nuts and all that. So what they did was they entered into agreement with Aberdeen Railways. Okay, they entered agreement with Aberdeen Railways to provide raw materials to Aberdeen Railways. Now, the court says that this is a conflict of interest. Why? Because you are a director for Aberdeen Railways. You also a director for another company. So when Aberdeen Railways enter into an agreement with the director's personal company, so when this director make a decision for Aberdeen Railways, is it for the best interest of Aberdeen Railways, or is it for the best interest of the director's personal companies? So there is a conflict of interest. Okay, there is a conflict of interest. But you may wanted to ask, but Sharil, what if the director, okay, the director's personal company provide a competitive price to Aberdeen Railways? So there's no problem, what? There's no problem. But then the word here, if your price is competitive, okay, why not Aberdeen Railways enter into agreement with other companies? Why must it with your personal companies? So when you make a decision, which hat are you wearing? Are you wearing the hat of Aberdeen Railways, or are you wearing the hat of your own personal companies? So there's a conflict of interest. So the court here says that the moment you think that you are in the contract that you're going to embark or you're going to enter is a conflict of interest, conflict with your personal interest, then you need to back down. Okay, you do not put yourself in the position whereby your interests may be conflicting with your the interest of the company and your personal interests. You must not put yourself into that position. So it's very restrictive. Okay, the common law says that you cannot put yourself into that situation or into that position at any time. Okay, it's very restrictive.
Sir,
Yes.
if let's say their own company can is how about the situation like you are the director, example you are the director A in one company, and then you have another company which it help the company A profit. So if like we provided as raw material to the company A in a cheaper, yeah.
Yep. So now, under the common law position, like every railways company against public operators, you cannot. Okay, you can't at any time do things like this. Meaning, every time there's a conflict of interest between the interest of the company and your personal interest, then you cannot do this. But under the Companies Act 2016, Section 219 and 221 says that in the event there's a situation whereby there may be a conflict of interest, what you need to do is only to make disclosure. Okay, you tell the other directors saying that, hey, look, our company is going to enter into agreement with company B, and I'm now making a disclosure, full and frank disclosure, that I am also a director in company B. Okay, so now it's up to you guys to decide whether we're going to proceed with the contract or not. And then you excuse yourself from voting in that decision. You need to get out and let the other directors to decide whether to proceed with the contract or not. So, Nurul Ain Salwa, to answer your question, in that position, the director need to make a disclosure according to Section 219 and 221 of the Companies Act 2016. All right. So,
Okay.
but then,
Noted.
yes. Yes, noted. Or you want to ask some more? Okay. But sometimes, yeah.
No question.
Right. So, but sometimes I find it very disturbing. Okay, disturbing. Why? Because assuming that the director is a very influential director. Okay, the CEO of the company, for example, or the chairman of the company. And he made a full disclosure, okay, to the other directors that he may have a conflict of interest. So he excused himself from making a voting to vote for that decision and let the other directors to decide. But in theory, yes, it is a good practice. But in practical, if the director who makes that disclosure is a very influential director, do you think that the other directors would dare to vote against giving the contract to the other company whereby that company have not connected with that directors? Okay, so
Of
course not, right? If you wanted
yeah.
to in that company to be extended for quite some time, then you just follow along. All right. So in theory, yes, it is good, but in practical, it may not be what do you call this? It may not be practical enough. Okay. Okay, that's life. What to do? Okay. Right now, let's go to this. Okay, duty not to make secret profit. In the case of Cook and Dix, okay, 3 out of 4 directors in a Canadian railway company diverted a contract in which the company was interested to another company formed by them. The same as Blakey Brothers just now. Okay, And it was held that the contract was one which in equity belonged to the company and the director must hold it on behalf of the company. But in this Cook and Dix, what the court said that, okay, they say that whatever decided in Blakey is correct, but assuming that this company pays the director's personal company, right, something, right? So that director, okay, hold that payment on trust of the company, meaning they need to return the payment to the company. So Cook and Dix extended that fiduciary duties. Okay, but then yet this is an English position whereby in Malaysia it's not applicable, because the moment you disclose, the moment you make a disclosure, then you're okay, right? You're okay. So Blakey Brothers is not applicable. Cook and Dick is not applicable anymore. Okay, it's only applicable when you do not make disclosure. Then this Blakey Brothers will be applicable. Cook and Dick will be applicable again. Right. Directors part 2. Okay. Okay, but this is quite technical. Okay, this is about technical. It's about loan to directors. So section 224 says that loan to directors, except for exempt private company, a company shall not give any loan, guarantee, or provide any security to the director. Meaning, any company except for exempt private company cannot give loan to his director. The question is, what is the meaning of exempt private company? Exempt private company means the company do not have more than 20 shareholders, and none of that 20 shareholders are corporations. Means all the shareholders of that company are individuals. Then you fall under exempt private company. So if you're exempt private company, you can give loan to your directors. You can guarantee your directors, or you can provide any security to directors. But if you're not an exempt private company, meaning your company have more than 20 shareholders, or even if your company have 20 shareholders, but one or some of your shareholders are another company, then you are not an exempt private company. So you can't give loan to your directors. Okay, so what does it mean by loan? Okay, what does it mean by loan? Okay, section 224. Section 224 says, all right, 224 says, a company shall not make a loan to a director of the company or of a company which is by virtue of section 7 is deemed to be related to that company. All right. And then what does it mean by loan? Okay, what does it mean by loan? Loan is a direct loan. Okay, meaning a company give, let's say the director wanted to buy a house, for example, or wanted to buy a private jet. Do not have money, so the company giving a loan, direct loan to the director to buy a private jet. Cannot. Okay. Or the director make a loan with Maybank or with CIMB Bank. But the bank would require security. So the company is guaranteeing the loan made by the director. Right? So that is considered a loan as well. Or providing security, meaning to secure the loan given to that director by Maybank. Maybank will now charge the asset of the company. That is meaning of providing security to the director. So cannot so. So section 224 says you can't do this. Okay, you can't give a direct loan to your director, or you cannot give guarantee or security to the loan given to the director. You can't do this. Okay, why? Because a director may abuse their powers, meaning they may take the money from the company to benefit themselves, right? Or they make loans, a personal loan, but the company is guaranteeing that personal loan given to the directors. So that would put the company in a very serious, dangerous situation. All right. So you guys understand this about the loan given to the directors? Okay, right? It's quite straightforward. And then section 224, okay, says about, just now is about loan to directors. Section 224 is about loan or security given to person connected with directors. Okay, meaning the loan now is not to the director himself, but to the person connected with the directors. So under section 107, it defines what's the meaning of person connected with directors. All right. So section 107 says person connected with directors are members of the director's family. So what is the meaning of family, director's family? It refers to spouse of the director, meaning the husband to the to the director, or the wife of the director. All right. And then parents of the directors, the children of the directors. That includes the adopted child and stepchild. Brothers and sisters of the directors, and the spouse of the director's child, brothers and sisters. Okay, this is what we call director's family. All right. Okay, so this is what we meant by person connected with directors. Okay, it's quite straightforward, right? But what about the, let's say, the mistress of the directors, for example? What do you think? The loan was given to the mistress of the directors. Does it fall under section 2? Or the director, they have a girlfriend, for example, and the loan was given to the girlfriend. So what do you think? Does it fall under section 197, person connected with directors?
Yes.
Just now I said the mistress, right? I wanted to ask you guys something. Difference between mistress and concubines.
Sorry, sir, cannot hear you.
What's the difference between mistress and concubine? Is it the same, or is there any different?
The mistress you married to, is it? Huh?
I
don't know.
What the difference?
I agree with you.
What is the difference between mistress and concubine?
Actually, it's the same, but the status I think it's the same, but the status may be different.
Okay, what's the difference? The status? What the different status?
For mistress, maybe it's like you can be anyone. To whom the lowest ranking based on the hierarchy.
I can send the content in your intonation. All right, then what concubine? Higher ranking, is it?
Yeah, something like that.
All right. Yeah. The difference is, mistress, you're not entitled for inheritance.
The other way around.
For concubine, you're entitled for inheritance. All right. Next question. Okay, which one better? You wanted to become a mistress or concubine?
Mistress.
That's a question and a half.
The answer is
neither.
Neither. All right. Right. This is a trick question. I always ask person. Okay, after I explain the difference between concubine and mistress, then I ask them, which one do you prefer? You wanted to become a mistress or concubine? And some people take some time to answer, and then sometimes some you say I rather become a concubine. Then I say, It's a trick question. The answer should be neither. Okay, you shouldn't have choose either of them. All right. You should choose to become a legally married wife, not either mistress or concubine. So, all right, that's a trick question. Trick questions. Okay, forget about that. But it has a legal implication. Yeah, legal implication. If you are mistress, you are not entitled for inheritance. But as a concubine, you are entitled for inheritance. Yes.
So mistress have any legal relationship document like the marriage people have?
It's like no, as a mistress, you do not have any rights because there's no relationship. Okay, now, okay, this is it's a bit controversial, right? This is controversial. But I just wanted to discuss this on the perspective of the law. Why do you think that the gay communities, okay, the gay communities in the Europe, in America, in the US, they fight for what they call this equal marriage or equal rights for marriage? Why do you think that?
Interesting point.
Why do you think that?
Maybe
Yeah.
because of the religion's law.
Not really. Not really.
I think, doctor, they want to share their what it called their property or something else, so that legally they can be owned by his husband or wives. What they choose, legally they can own.
Because if you're not legally married, okay, you are partners. Okay, you are gay. You are living with your partners for whole of your life. But when you die, when this person died, the partner get nothing. Why? Because they are not legally married. Okay, they are not legal, just like a mistress, meaning the status just like the mistress. But if their marriage is recognized by the law, so the partners, the surviving partner, will be entitled for inheritance. So that is why the gay community is fighting for equal marriage rights. Well, that's just for the sake of arguments, right? I don't say that I support or do not support that position. All right. The discussion is only meant for legal discussion. Okay, legal discussion. You don't see after the Sharin. Yeah. You don't see after the Sharin is position is against or for of this issue. No, don't say that. This discussion is meant for discussion only. I hold my personal view for myself. Okay. All right. Section slide 18. Okay. Prohibition of tax-free payment to directors. Section 226 says that you cannot pay remuneration to directors free from income tax. You cannot. Okay, you cannot do this. You cannot exclude this provision in the company constitution, meaning you cannot say that you provide the constitution of me saying that you're going to pay the directors free from income tax. Okay, whatever remuneration that you pay to the directors must be subject to tax. Okay, that's section 226. 227, payment to director for loss of office. Now, let's say you remove a director from his position as a director, then you said you wanted to compensate for his loss. You can't. Okay, section 227 says it unlawful. Okay, unlawful unless you disclose to the shareholders. The shareholders agree by a resolution to compensate these directors. Okay, this section 227. And then directors cannot transact with directors, substantial shareholders, or connected person. Directors cannot acquire shares or non-cash asset of requisite value, dispose shares of non-cash asset requisite value, meaning to say, now companies have assets and non-asset, right? So the law says that you cannot dispose, as a director, you cannot dispose a substantial asset. Okay, so what is the meaning of this substantial asset or exquisite value? So for public company, is the same value prescribed in the listing requirement of the stock exchange where approval of the shareholders at the general meeting is required. For private company, non-cash asset is whatever more than 250,000 or not more than 10% of the company asset but not less than 50,000. Meaning to say, for private company, a director cannot dispose of non-cash asset of 250,000 or more than 10% of the company asset. You can't do this. Okay, you can't do this for private company. Okay, all right. This public company, you can dispose any asset which is whatever asset which is more than provided by the shareholders approval. Remember just now about Petra Perdana case is this one. Okay, this one whereby the director dispose of the asset above his limit set by the shareholders. Okay, this is Petra Perdana just now. Okay, this is Petra Perdana for public company. Right. Section 231, Director Service of Contract. For public company, the director personally undertake to perform as a director. And then this contract shall be kept at the registered office and made available for inspection. And who can inspect this contract? For example, a company wanted to appoint a director. So the company entered into agreement with the director. So of course, this agreement will include the benefit and payments to the director, right? And sometimes it was not disclosed to the other shareholders. And if the shareholders wanted to inspect this contract, okay, made by the company and the director, the members can, or the shareholders can, but the shareholders must have 5% or total paid up capital, or 10% in the case of public companies without a share capital, have right to inspect the contract. Meaning any members, okay, for in private company, any members which have 5% of the total paid up capital can go and inspect the contract of the director and the company. Okay. Right, that one, service contract. And then proceedings of the board of directors under the third schedule. This is, you have a chairperson, then you have a notice of meeting, method of holding meetings, quorum. Okay, all this are spelled out in the third schedule of the Companies Act 2016. Now, proceedings, okay, in paragraph 4 of the schedule say that notice to be given to all directors in Malaysia. Now, the question is, what if the director, one of the director is not in Malaysia? Okay, so there is a problem here. Okay, there is a problem here. If all the director in Malaysia, then you need to give notice. But what if one of the director is not in Malaysia? You don't have to give the notice to directors? For example, like you wanted to remove this director. Okay, if you wanted to remove the director, you need to come up with the resolution, shareholders resolution. So you need to give notice to these directors. Okay, need to give notice to the directors. But then you waited until the director go out from Malaysia. Then you serve notice to all the other directors, but you do not give to this specific director because he's out of Malaysia. And when this director come back to Malaysia, suddenly, oh, okay, decision will be made that you are now be kicked out from the company. Okay, so this is some possible dispute lah, meaning there's a lacuna in the law here. Okay, lacuna in the law. And paragraph 6, allow for meeting through audio, visuals, and online meeting, meaning they can have meetings like this Microsoft Teams, right? I think it's now normal, especially during the MCO. It's normal. Paragraph 7, okay, board shall fix the quorum, or if not fixed, will be based on majority of the directors. Meaning, the board shall say that what is the quorum, or how many directors must attend the board meeting. Okay, that paragraph 7. And paragraph 12, director assumed to agree with the resolution unless he vote against the resolution. Now, here again, there is a possible dispute. Why? Because let's say you have 10 directors in the board directors. Then if you, as one of the directors, doesn't agree with that resolution, you need to vote against that resolution. It doesn't, when you abstain from voting, then it is assumed that you're not against that resolution. Okay, so this is something that a director must understand, that if you don't agree with the resolution, you need to vote against. It's not sufficient for you to just abstain from voting. Okay, that's not count as voting against the resolution. Okay, you need to vote. Okay, you need to vote. All right. That's the end. Okay, that's all. That's all. Okay, thank you. Thank you. All right. Any question? Ada soalan? Ada soalan? Any question?
Sir, what if for 2 years the board of directors didn't conduct the meeting for almost 2 to 3 years?
Then the company is basically going to be a dormant company, and it's going to be, at the end of the day, going to be strike off from the registry. Why? Because every year, the company need to submit certain report to the Companies Commission of Malaysia. The submission of the report requires a director's resolution. So if directors doesn't meet for 2 or 3 years, meaning there's no report going to be submitted to the Companies Commission of Malaysia. So if there's no report, for example, like there's no report on the audited financial report and all that, then the company will be deemed to be dormant company, and the Companies Commission of Malaysia may strike off that company from the registry. That is the practical effect of not having any directors meeting for 2 or 3 years.
Okay, sir. Thank you. One last question from me.
Yes.
What if the board of trustee doesn't attend meeting for 3 times straight?
Board of trustee, yeah.
Yeah.
All right.
Because the board of trustee is appointed by the Sultan.
Okay. Now,
Okay.
I must admit that I'm not really well versed on trustee. Okay, all along I deal with companies. All right, company. I'm not really familiar with trustees. Meaning board of trustees and all that. Arif Daniel, I can't answer your question because I can't pretend that I know the answer.
Okay, sir. Thank you.
Okay.
Thank you so much.
I don't deal with trustees. I don't deal with trustees. But
Okay, all right. Thank you, sir.
It's a good question. I try to find out the answer for you.
All right. Thank you very much, sir.
Any specific trustee that I need to know about, so I can do my research, very focused research on this?
I will PM. PM you, sir.
Alright, because ada trustee, tiba-tiba you're talking about other trustee.
Yeah.
And then
Because I can be terminated. Okay.
Okay,
All right.
alright.
Thank you, sir.
Recorded. Is it recorded? No, no. It isn't.
All right.
We take it aside. We take it aside. All right. Any other question? No question. All right. Okay. There's no question. Then we finish for the day. And next week, we're going to talk about law of agency. And before that, on the 11th of November, we're going to have a midterm test. Okay, midterm test for our subject. It's going to be MCQ, and no class on the 11th. Meaning, you just go to VLE, answer your midterm test, MCQ test, for 1 hour or 2 hours, something like that. Then that's it. Okay, there's no class on that night, on the 11th of November. Question will be from the Malaysian legal system up until the law of agency. Okay, law of agency. Why? Because we took 2 weeks for this Companies Act. So I'm going to cover law of agency, but I may drop the what they call the sale of goods, right? And then after your midterm exam, it's your midterm break, right? Then after midterm break, then we're going to proceed with the competition law, competition law, anti-monopoly, and all that. That's the highlights of this course, right? The highlight of this course, the competition law as well as the intellectual property law. Right. Okay. No question.
Essay question. Is it an essay question or MQA?
Bukan MQA.
MQC. MQA is
MQC. Sorry.
MCQ.
MCQ.
CQ.
You get my point. You get my point.
Yeah. You make my day.
Am I right? It's an MCQ, multiple choice question. Right? No,
Okay.
no. Well, I did not meant to laugh at you. It's just that every day I need to deal with MQA, with all this syllabus, that. So when you talk about MQA, I'm like, yeah, I hutang them something, all right? Okay, all right.
Alright.
I see you guys next week. Yeah, so we're going to talk about law of agency and partnership. All right.
All right.
All right, guys. See you tomorrow.